Thank you for being here, Ken.
Hi, Carmen. It's a pleasure to be with you today.
I'd like to ask you, from a former Florida prosecuting attorney's point of view, could you walk us through the legal process for a murder case like that in the case of Michael Dunn?
Yeah, well, Florida is pretty similar to most states. Basically, there's the arrest and the charging phase, which is the responsibility of the criminal prosecutors. Here we call state attorneys. In some places, they're district attorneys. They're charged with the task of deciding what charges they should file and whether or not they believe they would get a conviction on those charges. In the Jordan Davis case, Michael Dunn was charged with first-degree murder and 3 counts of second-degree attempted murder with a 5th count of firing a firearm into an occupied vehicle. The case took about 18 months to prepare, and we are obviously at the end of what we call guilt phase. The prosecutors could have chosen, because it was a capital case, a first-degree murder, whether or not to invoke the death penalty. However, the state attorney in Duval County, which is Jacksonville, Florida, decided not to go for the death penalty. And so pretty much we select 12 jurors for this type of case, and they listen to the evidence as put on by the state of Florida against Mr. Dunn. And then the defense, if they choose to do so, has the opportunity to mount a defense.
So let me ask you, when that happens, the type of instruction that's provided to juries, does it include the fact that what they're expected to do is very specific?
The jury instructions in Florida, Carmen, are decided by the legislature. We get changes in them all the time. I believe during this trial there was a change to one of our manslaughter charges as the trial was going along. And so we have to be updated at all times as to what the jury instructions are. But in every county in the state of Florida, for whatever charge you have, we have the same jury instructions that are read by the judge at the end of the evidence part of the trial, the end of the closing statements, as people are familiar with. And the judge reads those instructions and in some cases prints them out, and each juror has them to take back with them into the deliberation room. So it will tell the jurors what they must find as far as evidence is concerned as to whether or not the state attorneys, the prosecutors, have met their burden. Meaning, if a particular crime says you have to prove A, B, and C, whether enough evidence has come out that the state of Florida has proven A, B, and C to sustain a conviction. And the jury instructions will also give definitions of certain things, for, as in this case, self-defense and what self-defense means. But the instructions are very clear and specific. Jurors do not have to have any special training to, be a juror. Pretty much a citizen of the state, and you're randomly selected, and you're expected to be able to deliberate amongst yourselves, read those instructions, and determine whether or not the criminal prosecutors have put on sufficient enough evidence so that they can sustain a conviction.
Do you think that juries tend to be more reactionary and more emotional and don't heed those instructions as much as they should?
Well, Carmen, I can tell you from my experience, being a former criminal prosecutor here in Clearwater, Florida, I've tried my share of jury trials, and my general consensus is that jurors tend to get it right. They tend to get through the legal minutia, and they have certain, like a gut feeling with regard to the evidence that is presented, and they tend to get it right from my experience. There are times, and what I think you're referring to is jury nullification. And jury nullification pretty much means that the jury believes a certain outcome should happen regardless of what the law says. So if they feel sorry for a person, they let them go. Or if they're angry at someone, they convict them. However, in Florida jury instructions, the judge actually gives the jury an instruction at the end of the trial that says you should not decide the case because you're angry at anyone or that you feel sorry for anyone. So the instructions based on probably history, have been updated to let jurors know just apply the law to the facts that you heard in the case. But generally, jurors tend to follow the law. It's not an easy job, but they tend to follow the law.
So I guess with the case of Michael Dunn being seen by so many people nationwide, there is a lot of information that they're not privy to because they're not in the courtroom. They're also not in the jury room, so they don't really have an idea of what's being deliberated. When there is outcry like this, as well as in the Trayvon Martin case, as a former prosecutor, what can you provide in terms of insight into the process that would help people understand that it's not cut and dried, that that there wasn't a miscarriage of justice, or if there was, it was more of a technical issue?
Well, Carmen, that's a great question. Pretty much when the nation learns about a case, it's what we call a high-profile case, and I've had my share of those as well. High-profile cases are different in the sense that everyone is aware that there's a camera there. The media is obviously involved. There are questions that are going on, and sometimes you hear the statement that the case is being tried in the media. Unfortunately, the media, especially if they're not located in the state where the case is occurring, may not understand the minute details with regard to the law or the processes and procedures that occur here in Florida, which may be different than other places in the country. But with regard to whether or not the jury gets it right and what the media perceives are two different things. For example, in this case, Mr. Davis's case, it received a lot of media attention, obviously because of the Trayvon Martin case, which has people put different political spins on it, and there are different agendas that they're trying to push forward. I can tell you that pretty much the jury in this case, 12 people, had a makeup of men and women, African American, white, Asian, and Hispanic, which gives a broad spectrum of what the community should be. And that's what you want on a jury. Oftentimes, however, the media takes hold of a case for whatever reasons, whether they want to, bring attention to a certain issue, which is always important. But sometimes the media tends to have a political agenda or a hidden agenda, which is very different than what happens in the courtroom. So as you stated earlier, what people don't see are the exclusions of certain types of evidence that may not be relevant under our evidence code, that may sway a jury one way or the other too unfairly. And so the defendant, the person charged, Mr. Dunn in this case, has certain constitutional rights that we all enjoy in this country. And it's up to the prosecutors to be able to, within that code of evidence and not violating his rights, be able to provide evidence to the jury to be able to sustain a conviction.
Do you think the charges that were brought against Mr. Dunn were appropriate? Or were they overreaching in some cases, or do you think that there wasn't enough focus on the lesser charges that might have been able to have given outsiders a better view of what was going on?
Right. Well, I can tell you this. I've followed the case a little bit and watched the media, and this particular state attorney in Jacksonville has been accused of doing just that, overcharging. And what does that mean? It's when you charge a crime that is so high, the burden is so high for the government to meet, that the jurors, when they don't see all that evidence, they have to acquit a person. This particular state attorney has been accused of that in the media on more than one occasions. For example, in the Trayvon Martin case, she was similarly accused of charging high, and that she did so for political reasons because of the outcry of the community. But I can tell you there are times when prosecutors will charge high But there are safety mechanisms that are put in place. For example, as a defense attorney, which is what I do now, criminal defense, there are mechanisms in place under the law that even if a prosecutor overcharges a case, there are little tools that are in the arsenal that we can use, such as motions to dismiss. If there's not enough evidence, you can go before the judge to do a motion to dismiss. And then if that doesn't work, right in front of the jury, the state of Florida, the prosecutors have to meet that burden. And at the end of their evidence, which we know the state resting, when the state rests, the defense has an opportunity at that time to make a motion to again dismiss the charges, saying there's not enough evidence to go to the jury. And more often than not, the judges deny that and allow it to go to the jury, and then the jury is the final say. Along with overcharging, in Florida, as in many states, the prosecutors will charge a person with a certain crime, but in many instances there are what we call lesser included offenses, meaning that if the evidence that you heard is not enough to prove the top charge,
right,
the jury can actually come back and say, well, the evidence didn't prove the top charge, but it proved something lesser. For example, in a murder case or a homicide case, some of the lessers are manslaughter. And the difference is, not to get too legal with it, but with first-degree murder, that means you had premeditation, that you wanted and intended to kill this person. If the jury finds that a person, for example, in this case, they couldn't make a decision, and that might have been the problem that they were having, is that if they didn't see the evidence that a person planned to kill another human being, then that's not premeditated first-degree murder. They can find second-degree or manslaughter, which means that the actions that the person took were so reckless that they knew or should have known that their actions would have caused death, and then caused the death of the actual person. So in this case, the lesser included charges were also available to this jury. However, they had some difficulty in reaching a verdict unanimously. And that's what a lot of people don't understand, is that the 12 jurors that are back there have to all agree to the same verdict.
Right.
And as you know, that could be hard sometimes to get 12 people from different backgrounds to come to an agreement on a verdict. So if they cannot unanimously agree as to what the verdict is, and cannot decide, as they did in this case with the top charge of murder, then it results in a hung jury.
I guess my thought is, if everyone is supposedly doing their part, but it comes down to the manner in which the information is perceived by the 12 jurors, and you have what you say is an ideal jury of a broad spectrum of people, then you tend to come across something like this where you're not sure that you're going to get 12 decisions that are all the same,
right,
because we are basing it on the differences of those 12 people. Yet there's an outcry when there are hung juries, but if it had been 12 white people or 12 black people whose experiences or backgrounds were similar, there would have been even more outcry, I would suspect. So what's the disconnect there?
Well, I can tell you this, whether there were 12 white jurors or 12 black jurors, each person brings their own unique experiences into that room. And one thing that people don't realize is that once you're selected to be on a jury like this, you're not allowed to talk to each other about the facts of the case until the judge gives the case and reads the instructions to you. So it's kind of weird. These 12 people are together for days. They can talk about sports. They can talk about the Olympics. They can talk about various things, but they can't talk about the facts of the case. And neither can they access their mobile devices or look at the news or talk to family when they go home. They take an oath to be able to just listen to the evidence individually. So the first time that they actually give their opinion as to what evidence they believe they saw in the case is when they get back in the deliberation room. And as you can imagine, the instructions say that the deliberations should be run like a board meeting. that one juror should be selected as the foreperson or the chairman, who pretty much doesn't impose their opinion on the person, but they keep order in the room, which sometimes can get pretty heated back there. But with that being said, you have 12 different people who have to decide and give their own opinion about what they thought they saw and heard. And in long trials, that can be difficult because after 10, 20, 30, 40 witnesses, some of them as experts giving technical information, some people remember things one way, some people remember things the other way. And so the argument goes out. But the jury instructions that are read by the judge pretty much tell the jury that if they have a biting conviction of guilt, and that might be, in your gut, the evidence is there and you feel that the state of Florida or any prosecutor has met their burden, then you should come back with a conviction of guilty. And that's a high burden in our country. It's the highest legal standard we have. The criminal cases that come into courtrooms, the standard is beyond and to the exclusion of every reasonable doubt. So that's a very high burden. The only thing higher than that is beyond a shadow of a doubt, But the prosecutors have their work cut out for them when they do that. And so if individuals believe that, that the prosecutors didn't prove a certain element, whether or not, for example, in this case, Mr. Dunn knew that he planned to kill these individuals, then they have a problem with premeditation. And so that is why a lot of times people are saying, well, why would the state attorney charge so high a burden? Why don't they charge something like manslaughter, right, which the jury may have found if it was second-degree murder or manslaughter. However, I'm a little confused myself. I can tell you from my experience, the jury found Mr. Dunn guilty of 4 out of the 5 charges. 3 of those were attempted second-degree murder of the other young men who lived, but couldn't come to the decision on the main charge for Mr. Davis, who died. We never know what happens in a jury room. It's not recorded. The judge actually lets the jurors know that they're free to talk to anyone they want, but we cannot go and approach them. But I can tell you, I bet that prosecutor and that defense attorney would love to know what was in their minds when they were back there, because it helps them prepare in case there is another trial in this matter.
So I find that interesting because as an outsider looking in, the only information that we're provided is through the media. 9 out of 10 times in most cases, the prosecuting side and the defense side don't necessarily come out and give comments unless they feel it'll help their case, I suppose.
Yes, there are various reasons why people speak to the media. I can tell you when I was a criminal prosecutor in Clearwater, there was a standing rule that we didn't comment to the media. We didn't try this case in the media. We brought our case, we investigated it, we presented to a jury, and we lived with that verdict, which is what we do across the country. And so it's unfortunate when outcries actually happen. No one's usually happy at the end of these type of cases. And in fact, everyone loses. This young man lost his life at a precious young age at 17. And the defendant, Mr. Dunn, is looking at a minimum of 60 years in prison. He's 47 years old. He wouldn't get out till he's 107. So everyone loses in this type of tragic case. The outcry comes out because, for various reasons, as I said at the beginning of our interview, people have different agendas. So you have some that want to bring attention to problems with race in our country. And in Florida, we hear a lot about the stand your ground law. And this is one of those cases where, unfortunately, someone died. And stand your ground was kind of the basis for that. And to understand stand your ground, the old law used to be that you can use equal force with force. So a fist with a fist, a stick with a stick, a gun with a gun. And if you had the means to be able to get away from the danger, the law required that you did that.
Right.
The only exception to that was if you're in your own home or your place of business or your car. And that's called the Castle Doctrine, which was a case that came out that lets people know you don't have to flee from your house. You can defend your house. But in Florida, stand your ground was passed by the legislature. And stand your ground pretty much says you don't have to flee anymore. If you can get away, you don't have to. If you believe that you are in imminent fear of serious bodily injury or death, that you can use lethal force to stop that threat. In this case, I think the issue was that at least 10 shots were fired, 9 hitting this SUV with these 4 young men in it, bullets tragically striking Jordan Davis. Mr. Dunn didn't run. He didn't leave. And in fact, shooting 10 shots pretty much can be argued that it was out of anger that he did this. Some people argue that, no, it's out of fear and nervousness. You just keep your finger on the trigger. But I actually had an opportunity to hear the audio sounds of it, and there were a burst of shots, and then it was silent, and then there were another burst of shots. And I believe that's why the state attorney's office believed that it turned from fear and defending yourself to premeditation. And it's important to know when people hear premeditated murder, they think like the movies, you plot for months and weeks. Premeditation can take seconds. Once you know the fear is gone and you're safe, and then you continue either out of anger to continue to use lethal force, then it changes from self-defense to pretty much a crime. I mean, you can't shoot at fleeing people in a car.
From a criminal defense attorney's point of view, couldn't you argue, though, that the second burst was a knee-jerk reaction, maybe not out of fear, but out of that burst of adrenaline when you find yourself already in the midst of an action like this?
Well, as a criminal defense attorney, yes, I'm going to do whatever I can to defend my client. However, there's what we call a reasonable person standard, and there's a reason why jurors are not professional jurors. Like in some places, that's what they do for a living. In our system of justice, we take everyday people like you and me, bus drivers, school teachers, stockbrokers, doctors, and we bring those people into a courtroom to bring their common sense. And that's something I often say in trials, is don't leave your common sense at the door, members of the jury. Bring your common sense in with you. And so to answer your question, yes, it can be argued that a number of shots is because of fear. The person keeps pulling the trigger until they don't hear anything anymore. But in this particular case, and again, I didn't see all of the evidence, but I did hear that the audio, and witnesses say that Mr. Dunn got out of his vehicle and then pointed his gun at the fleeing SUV where Mr. Davis and his friends were in and continued to fire. I think that's a hard argument to make, that you're still in fear when you become the aggressor.
Right. But whatever the emotion was, or whatever the inclination was to why he continued, wasn't argued well enough, or else the jury might have all come back with, I understand that well enough to know that it went from being in fear to being the aggressor, and so then they could have proved their case. Now, I say that because I'm stepping into that area of learned behavior, and I wanted you to speak to this is where it becomes problematic when you ask for people not only to bring their common sense, but you ask them to bring how they've been raised into deliberations.
Well, we don't particularly ask them to bring how they were raised, and we tell them to bring their common sense. However, it is a truth that people do bring in how they're raised. They bring in their world, their experiences. And to let you know, I didn't see all of the evidence of how the prosecutors presented their case, but I can tell you that there were people that were convinced that the prosecution met their burden. And then there were people that believed that they didn't meet their burden. And how do we know that without being in the room? Is that they couldn't reach a decision.
Correct.
So that means that some thought the prosecution proved premeditation, and some people on that jury believed that they didn't. And maybe that stand your ground or or self-defense applied in this case. But you bring up a good point with people's experiences and upbringings. Again, this is another major case in the state of Florida that made national news. Race played a big part as far as the media is concerned. That comes into effect when, depending on how a person is raised, if they're raised that young black men are thugs, no matter what they do, then that person is going to have probably an unwarranted fear in seeing a group of young black men. And as we've heard time and time again, if you're wearing a hoodie or a certain type of clothing, you're presumed to be a certain type of person. But they could be college educated, just out to get a soda, and someone is in fear of them. And that could be based on either, upbringing, ignorance, or they intentionally have racist feelings. And that goes both ways, Carmen. A lot of times, you'll have reverse, where we have African American or Latinos seeing whites in a certain way because they were raised a certain way. And that's the danger about this particular law in Florida, is because it puts in the mind of the individual is whether or not you're in fear because I see 4 black men. The whole notion that when a white woman walks by 4 or 5 black men, she clutches her purse. Unfortunately, we'd love to live in a perfect world, but it's not a perfect world, regardless of what people say in the media, regardless of those who claim there's no racism. There might not be overt racism where people are burning crosses on your lawns anymore, but in our everyday actions, our behavior subliminally shows racism sometimes. And that's a danger when it comes into the courtroom. Justice is supposed to be blunt. But statistics show us, with regard to the death penalty, for example, that there are higher rates of minorities who are executed as opposed to whites. And these are studies that are, they're out there. How we look at sentencing guidelines, for example, the Department of Justice now is looking to correct the sentencing guidelines, particularly for drug use, where crack cocaine, you will get a mandatory, heavy sentence in federal prison, as opposed to powder cocaine. And everyone knew that crack cocaine in the beginning was in the inner cities, and so young minorities were given hefty sentences for possessing crack cocaine, whereas your more affluent suburbanites who were using powder cocaine would get, more of a probationary or a lesser sentence. And so the whole question goes to our criminal justice system as, is it certainly is not perfect, but it is the best system in the world. There are some countries where you don't get a jury, they take you out back and shoot you. Right. But we have to acknowledge that there's some flaws in the system because human beings are involved. The judge is not a robot. The attorneys are not robots. The jurors are not robots. And so you bring your experiences and your feelings in there, but what you try to do and what you're asked to do is to put aside your sympathies, your anger, whether it's at the lawyers. Is actually an instruction that says, don't decide the case because you're mad at the lawyers or you like the lawyers. There's an instruction that the judge gives, don't decide the case because if I look like I preferred one verdict over another. Trials are heated battles, and sometimes the judge yells at one side or the other. But there's a cautionary instruction that's read to the jury. Don't think I preferred one verdict over the other. You're supposed to look at the evidence as presented by the prosecutors. They have accused an individual of a crime. It is their burden to prove that the individual committed that crime. If they don't, then they have to let them go. And that doesn't mean they're not, they're innocent. It means that they're not guilty under the legal standard. A lot of people who are not innocent are acquitted because the prosecutors haven't met their burden in proving them guilty.
I wanted to bring to the table I want to bring to the table the fact that you are multiracial, that you were born in New York City, and that you practice law in Florida. So you have the unique and I think a magnificent opportunity to see it from a number of vantage points that the rest of the country can't. My first question, I think, in that regard is, as a black criminal defense attorney, can you speak to your experiences with your cases that I don't think the rest of the country would be aware of?
Um, I really don't see too much difference when it comes to race in the cases I have handled. I can tell you, you're correct. My background, my father was Irish. My mother was African American and Native American Indian. Growing up in the 60s in New York, people either turned their heads or made some comments, probably not as bad as it was in the South. But coming down here to Florida, I think that with cases such as Jordan Davis or Trayvon Martin, we see more of an outcry in the rest of the country and on the media sometimes than actually happens down here. I can tell you a lot of individuals weren't even aware this trial was going on. Unfortunately, and it's tragic that people are killed by guns. There are shootings. I mean, even as of late, there was a house party where a shooting went on last night. I mean, this happens all the time. And not to say that it should be accepted as the norm. However, shootings happen. They happen in Florida. They happen in New York. They happen across this country over silly things. I've had cases where, a person was shot and killed over $20. It's tragic. But my personal experience, it's something that you keep in the back of your mind when you try cases. My audience is a jury. And so I'm trying to pick jurors that would at least understand and give my client a fair shot and would allow me to challenge the state's evidence and cross-examination and to show that they didn't meet their burden. But in the back of every attorney's mind is the makeup of the jury. But I think that we overthink it sometimes. I actually, as I said earlier, jurors usually get it right. When they walk in that courtroom, they want to do justice. What should happen here? What's the right thing that should occur? And more than likely, they get it right. A lot of people see a hung jury as some problem, that the jury did something wrong. I can tell you, they spent a lot of time. They came in on a Saturday. For 12 people to agree to a certain thing, they must not have been convinced beyond a reasonable doubt that the state met its burden with regard to the top charge. Now, with regard to the lesser charges of manslaughter, I'm lost for words at that as well. I talked to some colleagues. I find it difficult that you find a person guilty of attempting to murder someone, but don't find him guilty of anything when it comes to the death of a young 17-year-old. But if the jurors come out and talk about it, I guess we'll shed some light on it. But if not, we really would never know. But it's important to know that jurors like you and I take time off. They're paid a nominal little fee and given sometimes very good food, depending on where you're at. But they're taking time out of their schedules to decide some important issues. And the jurors should be commended for their civic duty in coming in, because when the media beats up jurors, regardless of the verdict, or if there's no verdict, it's a mistrial, people don't want to serve on juries. And I can tell you my experience as a trial attorney is that the common sense, professional, analytical people, normally people try to find a way out of jury duty. Doctors and attorneys, because of their jobs, find their ways out. But a lot of people get on the jury, they give time in, and they should not be bashed, as in the Casey Anthony trial that we had here in Florida, or the Trayvon Martin case. They do a difficult task, and no one's going to be happy with the result in any case. Just by nature, there's two sides fighting.
Right. I have two final questions.
Sure.
One is, do you think, I feel that the choices of the cases that are being handpicked by the media and I want to say the word to exploit and put out there, tends to create this divisiveness in our country. Do you think that Florida, because of the Trayvon Martin case, has sort of been a targeted state because there have been cases afterwards that sort of fit that same mold and can continue to keep that flame going?
Well, I can tell you this, Carmen, without getting political on either side. There is a need for people to know what's going on in the country, and cases when a young person dies, black or white, are tragic. Then again, on the other side, there are those who exploit the cases for their own political reasons, some for something as simple as ratings for their cable shows. In any community, the death of a young man, a child, is tragic. The death of anyone before their time at the hands of a criminal is tragic. But there are a lot of issues going on. Florida is pretty much ground zero for a lot of these cases. There are about 15 or 16 states now in the United States that have similar stand your ground laws. Okay. And so Florida has just become the focal point because of cases like Trayvon Martin. But I think there should be dialogue. When a new law comes out, whatever it is, it takes time for the citizens, the legislature, the attorneys, the judges to figure out, was this a good law? Is it being applied appropriately? And unfortunately, people are dying. And if that means that people believe that they can pull a firearm out, I mean, I'm a gun owner. I'm not a radical Second Amendment person where the government is taking my guns, but I'm a gun owner. And that's one of the rights I enjoy here in the state of Florida. However, I'm a little outraged when people think that because of a crossed word, you can pull a firearm out and shoot to kill. We used to have, when I was growing up, sticks and stones may break your bones, but names will never hurt you. I mean, we don't do that today. We pull guns out. And there are a growing group of people that believe that we're turning into the Wild Wild West because of that, and are blaming that law. On the other side of that, there's a need to protect yourself. The police are not always around. You do have bad elements that are out there. So the majority of gun owners, we're in Florida, there are many, many gun owners who have concealed weapons permits. Mr. Dunn had a concealed weapons permit, which allowed him to carry a concealed weapon. But that doesn't give you a license to use that weapon. You still have to use common sense. And when you cross that line from defense into criminal activity, you're going to be held accountable, and you'll be judged by your peers.
Which leads to my final question. Do you think in this particular case, and I understand that I'm asking you your opinion, but for the reasons that I stated before, do you think justice was served in this case, in spite of all the outcry that's been going on there?
Well, I can tell you, I'm not the parents of Mr. Davis. I watched their interview. I could imagine losing one of my children, especially tragically like that. And so my heart goes out to them and to this community. My understanding, his birthday was either today or tomorrow, or would have been. That's hard, and so certainly emotion plays into it. However, what is justice? Well, in every courtroom you see Lady Justice blindfolded, and she's holding the scales. There's argument that justice is unequal, that minorities suffer. And traditionally, of course, no one can dispute in this country you would never get an acquittal of a black man by a jury of white men in the South back in the 30s and 40s. Just wouldn't happen. And in fact, there was a period, as you may well know, where women weren't even allowed on the juries. It was white men. And so if you were a black and accused of a crime, then you pretty much are in trouble. But with regard to this case, whether justice was done, Mr. Dunn is not getting out of prison. In Florida, we have what we call 10-20 life laws, which have to do with guns. And in the verdicts that came back with the jury on the remaining 4 counts, the attempted second-degree murder carries a 20-year minimum mandatory sentence, which means he has to do 20 years for each one of those charges. So that's 60 years. And that's day for day. There's no 50% time or 85% time. You have to do 20 years day for day. So he's looking at 60 years on those counts. Firing into an occupied vehicle is another 15 years. Okay, those are the minimums. He can get 30 years on each one of those. Those will be up to the judge. And currently they're doing a pre-sentence investigation, and that's a procedure done in Florida. If you've never been convicted of a felony, they do a background on you to give the judge a packet to help him with sentencing. But with regard to justice, you know, I don't think I can answer that because I'm not the family. It's easy to kind of sit outside of everything and look in. I can tell you based on my experience as an attorney, both a criminal prosecutor and a defense attorney, Mr. Dunn's not getting out of jail. He's going to be in there the better part of 60 years or so outside of an appeal. But for the family, justice may be a little different. They may want to hear that jury of their peers come out and say, Mr. Dunn is guilty of killing their son. And the fact that they were not able to reach a verdict in this case, the prosecutors in Jacksonville said they will retry this case with a new jury. Justice for them is probably hearing that their child was murdered, that this individual is guilty of that. And so from a legal standpoint, justice, yes. 60 years, he's going nowhere. But for the family, I'm certain that absolute closure will come when they hear what they believe the jury should say to them, that their young son was murdered in cold blood.
I guess my last thought is it's very difficult when you're expected to go into a legal proceeding and ask not to be emotional. But when you're on either side of that table, whether, you know, defense or prosecuting, you can't help but be emotional because your lives are completely impacted and changed forever based on this situation.
Mm-hmm. That's correct. And anyone that says there is no emotion involved is lying to you. As a defense attorney, it's a lot of emotion. I have this person, this individual who I'm charged to defend. Okay, regardless of what we think about this particular individual, from all the terrorists that we've charged, the great thing about our country is a system of laws, and that everyone is innocent until proven guilty by the government, whether that be the state or the federal government, and that's something that we are proud of. But when it hits home, or it seems that the facts are so heinous, the bringing down of the World Trade Center, emotion is going to get involved. As a prosecutor, you want to bring justice not only for the community but for the victims' families. The jurors want to get it right. So emotion plays to various levels in a court case, whether it's civil or criminal. However, we need to do the right thing, use our common sense, and make the right decisions in trying these type of matters, which are very difficult. Unfortunately, sometimes the media plays into those emotions and sometimes makes things a little more heated and worse than they should be.
I want to thank you. I know that the Good Men Project thanks you for this interview. I have been lucky to know that your closing arguments are legendary. So I want everyone to know, where in Clearwater are you located?
We're actually, our offices are located in the Tampa Bay area, just north, about an hour north of Tampa, in what we call Richey, Florida. We have another office further north in Inverness, Florida, but we primarily are here on the west coast of Florida, serving people in the Tampa Bay area. We provide criminal defense services anywhere in the state of Florida, and we are admitted to all courts, including the Supreme Court of the state of Florida.
Well, thank you very much for speaking with me today.
Thank you, Carmen. Take care.